like they're connected now. Mr. Martin, are you there, please? Can you turn on your video? There we go. All right, Mr. Martin, are you able to hear me okay?
Yes, sir.
Okay, we're on the record now in versus Dean Martin, case number 235199. The record should reflect Mr. Martin's presence today by video from the custody hall. If I could have counsel for your appearances on.
Sierra Cook on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of the defendant, Dean Martin.
The date time set for sentencing. Mr. Thompson, have you had a chance to go through the pre-sentence report?
I have, Your Honor, and I'll just briefly address, I apologize for not asking the court for permission to run this as a Zoom hearing. We had discussed at the plea that Mr. Martin was attempting to get into treatment. He did get into treatment over the holiday. I didn't advise the court that that's where he was, and so I appreciate the court's accommodation of hopefully allowing him to appear by Zoom.
Mrs. Coke, do you have any objection to proceeding today in this manner?
No.
Okay, then we'll go forward with sentencing. As long, Mr. Martin, as long as you understand that the fact that you're in treatment now isn't going to change anything about the way the court is going to sentence you in your case. Do you understand that?
Yes, sir.
Okay. So, Mr. Thompson, you did have a chance to go through the pre-sentence report.
I did, yes.
Mr. Martin, did you have an adequate opportunity to go through the pre-sentence report and speak with Mr. Thompson about that?
I talked to him yesterday about it. I just got it. It got sent to my daughter's house, and I just seen her yesterday for the first time. I've been here for 3 weeks. And so, you know, there was a couple of things that wasn't like accurate, but I'm not concerned about changing much of it. I mean, it's really, I don't think it's gonna help me or hurt me either way, the way it's written up. I live 20 minutes away from Grayling, and I was trying to get into the rehab, but it took me 6 months to get here because my Medicare was transferred from out of state to Michigan, so that's what took so long. And most places take Medicaid, they don't take Medicare, so I had that issue. But I was going to Grace Counseling throughout that time and going to meetings and before I came here, and I was doing everything under that I possibly could do, living in Crawford County.
All right. Are you prepared to go forward with sentencing today in light of what you indicated with regard to the pre-sentence report?
Yes, sir.
Mr. Thompson, aside from what Mr. Martin's indicated, are there any things that need to be corrected?
Yeah, there's some minor corrections, Your Honor. If we can turn to the second page one, so the fourth page overall, but it's also noted as page one.
Okay.
Evaluation and plan. Again, just some minor. There's a reference in the third paragraph to the town of Alpena. In that second line there, he lived with his father in Alpena. That should be Atlanta, Michigan. And when we get to that next paragraph, then, Your Honor, on that top line, it indicates no children. He has 2 children. So that we'd ask to update. The next line, Alpena, should be Atlanta again. Okay. And then if you go down one more line, talking about his former wife, indicated she had 2 daughters. That should be 1 daughter.
Okay.
And so, and as Mr. Martin indicated, you know, when you're looking at these Kentucky records from 20 years ago, I think Mr. Haven and I both agree sometimes it's a little hard to figure, completely unwind those, but we agree with the overall conclusion that there's 1 felony and 6 misdemeanors. I think that may have been wrong on our prior version of the prior record, the original page 1, but we agree that it's 1 felony and 6 misdemeanors. over 20 years old as the plan indicates. So those are our proposed changes.
All right, Ms. Coe, any objection to any of those changes?
No, and I was just gonna say what Mr. Thompson said on the face. It should say 1 felony and 6 misdemeanors, not 0 and 0.
All right. Any challenge? No, this is 1 year, so there's no guidelines. Okay. Ms. Coe, do the people have any changes, corrections, deletions?
No.
Anything on behalf of the people for allocation?
You know, his criminal history is really long. I mean, not really long, but really old. He only has the 1 felony and the 6 misdemeanors, but you know, they're 20 years old. In this case, he was a .176. He was doing an 85 and a 55, did not slow down. This is a pretty dangerous situation. I'm glad he's addressed this by going to rehab, which is why we gave him the plea offer we did, which is down from a 3rd to a 2nd. It's a substantial departure. I think the 30 days in jail, once he finishes the rehabilitation, is appropriate, and I'd ask the court to follow that recommendation. Thank you.
Thank you, Mr. Thompson.
Thank you, Your Honor. I do have the confirmation of his attendance beginning December 11th.
Yeah, you can.
Yes. And then, Your Honor, I mean, I can confirm, I spoke to him yesterday and today, both times he's at Nikoski Hall. So he's been in there since, every indication he's been in there since December 11th. He believes he probably has a couple more weeks before he's successfully discharged. I don't know if the court would consider giving him credit for any of that time against his sentence. I understand it's within the court's discretion. Mr. Martin understands he broke the law. He's certainly going to take responsibility, accept whatever sentence the court gives him. I will just indicate that this rehab is probably exactly what he needs. History would suggest this is an individual who just can't consume alcohol because bad things can happen. He'd had long periods of sobriety before this. He'd had some rough things happen in his life. He'd relapsed. He needs to be sober moving forward. He's done it successfully for some very significant blocks, and that's certainly his intention moving forward. We understand this is within the court's discretion. If the court gives him jail time, he's earned it. We're not saying he hasn't, but we'd ask the court to consider the rehabilitation he's undertaking, consider whether, perhaps he could be given credit for some of that time in the rehab. But in any event, Your Honor, Mr. Martin accepts responsibility and accepts the court's judgment in this matter. Thank you.
Thank you. Mr. Martin, was there anything that you wanted to say today?
Well, I mean, I don't agree with all the stuff that was written in the report, but I just got in my vehicle for a minute, and as I let off the accelerator, the lights come on, and I was trying to find a flat space to pull over, not a safe spot. I was hoping if I got off the road enough, I had 2 German Shepherds in my truck, and I was hoping if I did go to jail that, they wouldn't tow my truck and take my dog, because it's my support animal. And I also have my therapist here. She said she would testify on my behalf of my treatment here. And other than that, I accept whatever, it's my fault, Your Honor. I did something stupid. It was my first winter there in 40 years. And, I live out in the woods. I hardly ever come to town. And I made really bad judgment, and I should have known better because, I just should have known better. There's no excuse. I could sit here and think excuses, but I just don't have any.
All right, thank you. I did have a chance to review the pre-sentence report. So I'm familiar with the circumstances here that bring you before the court today. I'm also familiar with your background and your history and circumstances based on the information contained within that report. And, a couple of things I think that strike me. Number one, I guess you can hem and haw about the fine details of when you pulled over and why and so forth. But in my view, that's really a minor issue here. The issue is that you were highly intoxicated operating a motor vehicle at a high speed. And whether or not you're in a populated area or out in the woods on a back road, you still have the opportunity to encounter other individuals, other vehicles, unexpected things can happen. And it's a dangerous situation that you put yourself in, as well as the people that were in your vehicle, as well as anyone that you would encounter out on the road between town and where you were going that night. And, I read your description in here. You've got a lot of reasons why you went back to drinking, and maybe some of those are valid reasons for somebody to need help and for somebody to feel the way that you felt. But, if you would have injured somebody that you were riding with, or injured or killed someone else on the road that night, they don't care why you were drinking. All they care is that you were drinking and you hurt them or their loved one. And so I don't think you should be looking at this as trying to provide justification for why you were drinking and driving that night. And you need to start looking at it from the standpoint that regardless of how you're feeling or what you're going through personally, that doesn't give you any excuse or any right to put other people in danger because you're feeling bad. And that's what came out to me in reading your description of the offense and in listening to you here today. I feel like there's a bit of a lack of accountability for your own actions, and hopefully through the treatment program, that's going to get addressed, because I think that's a big part of you moving forward. That being said, I think there are certainly some positives here. You've shown periods of prolonged sobriety during your adult life. There's been a significant gap in any kind of criminal activity between this one and your previous one. So I certainly think there is a good potential for rehabilitation in this case, and the fact that you're seeking out treatment and actively engaged in that, I think, is also a positive for you going forward. And in that regard, to me, that's a positive, because that's going to help keep our community safer and prevent you from putting people in danger and acting the way that you did, and hopefully provide you with some mechanisms to deal with things in your personal life in a more positive way, as opposed to putting other people in danger. So I think there's a balance of things here. I think the recommendation is generally appropriate. I think some probation to monitor you is important as we go forward, to make sure that you're staying on the right track. I think that an important condition of that probation is that you continue with your treatment there, and that you successfully complete the program, and that you not leave against the advice of the treatment facility. So the court is going to make that a condition of your probation, along with all the other terms and conditions that are listed in the report. The court is going to impose 6 months of jail time. I'm going to hold that time in abeyance. The court will give you credit for the time that you've spent in treatment if you successfully complete that program. If you leave that program early, or for whatever reason, then the court will impose that jail time, and you'll have to report to the Crawford County Jail to serve that time. So again, an important component here is that you continue with your program and that you successfully complete it. If you do, and you otherwise comply with probation, you'll never have to serve that jail time. However, again, if you leave the program without authorization or without completing it successfully, or if you otherwise violate your probation, then you could be subject to serving that jail time. So again, I think it provides a degree of accountability for you, a consequence if you don't follow through, but also gives you the opportunity to get back on the right track and avoid serving jail time if you do the kind of things that we need you to do to ensure the safety of our community. So again, the court's going to place you on probation for a period of 18 months, 6 months in the Crawford County Jail with credit for 1 day served. That time to be held in abeyance subject to the conditions that I indicated. The court will order restitution in the amount of $100 for the OUIL testing, the crime victims assessment of $130, a supervision fee of $30 per month while you're on probation, court costs of $325, a fine of $200, attorney fees of $350, $50 state costs. Mr. Thompson, was there something?
Yeah, I just wanted to ask Mr. Haven, since we're not all in the same physical location, if he has the release releases he needs at this point, or if there's something we can do today, because I assume you're gonna be having to try to contact him and being in rehab. Have you gotten releases yet?
I have not received anything from Addiction Treatment Services, so if you could sign a release, with my name on it as your probation officer, that way I can keep updated with your progress.
So Dean, probation officer John Haven is indicating you need to fill out a release of information for John Haven so he can contact you at the facility and get your probation started. Do you understand that?
Yes, my therapist had emailed him to tell him I was here, and she'll take it for me.
All right, I just want to make sure we have the necessary releases so you and John get started on probation. That's all I had, Your Honor. Thank you.
Okay, thank you. Ms. Stoke, anything further that we need to address?
No, thank you.
Mr. Thompson?
Nothing further. Thank you.
Thank you. Mr. Martin, did you have any questions at all?
If I could ask for an extension here, I may or may not be able to get one. If I could get an extra 30 days here, would that count towards any jail time or?
Yeah, anytime that you spend in treatment, if you successfully complete the program, the court will give you day-for-day credit.
I really appreciate you, Your Honor. Thank you very much.
All right, that's all we have for the hearing today. Good luck to you going forward, Mr. Martin.
Thank you.
Thank you.
And we have Mr. Webb here in the courtroom. Mr. Webb, if you could come forward, please. Eagle versus Douglas Webb, case number 235246.
You're welcome.
Counsel for your case.
You're welcome. Yeah, the people.
Thank you, Your Honor. Jason Thompson, on behalf of Defendant Douglas Webb.
Oh, I have a note here, Mr. Webb. Indicates that the agent wasn't able, Mr. McDowell, maybe you could just make a record for me of what we have here and what's happened since this.
So, since I filed that report, I haven't had any contact with Mr. Webb.
Okay, and what efforts?
Oh, okay. After his plea, I met with Mr. Webb in the back hallway. At the time he was lodged, he was getting out on a PR bond. I provided him with the pre-sentence information packet and my business card. Had him an appointment set up for Monday. I did find out later that day that he was transferred to Roscommon County Jail due to an open warrant there. Made arrangements on Monday to go interview him there in Roscommon. But by the time I got there, he actually went to court and was released from Roscommon County Jail. I didn't hear anything from Mr. Webb. I went to his address that's listed with the court. The person who made contact with there said they haven't seen Mr. Webb. He doesn't live there. And that was it.
Thank you. Mr. Thompson, anything that we have to
Similar position, Your Honor. In speaking to Mr. Webb, he doesn't have a working phone. I didn't have, he stayed with a friend now. Nobody knew what that was going to be at the time of his release. I haven't been able to have contact with him. So similar position to Mr. McFell.
Mr. Webb, anything you wanted to say on that? So far. All right. Mr. Webb, the court has concerns that we're going to be able to get a hold of you to complete this pre-sentence process. Part of your bond requires you to participate in that. If you fail to do that, so the court's going to revoke your bond. Have you taken into custody today? Mr. McFalda, you can meet with Mr. Webb at the jail and the court will reset this for a sentencing.
I will, Judge.
I can talk to you in the hall, but you're gonna have to go with this gentleman. What do you want?
Our next hearing set for 9:45 will be recess. On the record in People versus Joshua Checks, this is case number 235172. The record reflects Mr. Checks is present here today.
You're talking on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of the defendant Joshua Checks. Your Honor, we received the court's written opinion regarding the plea. We do intend to enter that plea. That's our intent today. The written plea offer that I have for the prosecutor's attempted count 1, criminal sexual conduct, 3rd degree, person 13 through 15, with HIDA sentencing. Mr. Checks is prepared to acknowledge his rights and make those admissions today.
Thank you, Ms. Coe.
That is a correct statement of the offer.
Mr. Checks said you had an adequate opportunity to speak with Mr. Thompson about this plea.
Yes, Your Honor.
And is that how you want to proceed today?
Yes, Your Honor.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I swear that my testimony I'm about to give will be the whole truth and nothing but the truth, so I'll just get that.
Thank you. You can lower your hand. Mr. Checks, are you currently on any kind of probation or parole?
No, I'm not.
Right. And you understand that by pleading guilty to criminal sexual conduct 3rd degree as an attempt, that the maximum penalty you could face would be up to 7.5 years in prison.
Yes, sure.
With that maximum possible penalty in mind, what is your plea been charged today? Okay. Now you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you if you're at trial. There's a question in those witnesses. You have the right to have the court order any witnesses on your behalf if you're at trial. You have the right to remain silent during a trial, to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights.
Yes, Your Honor.
You understand that you're giving up and waiving all of those rights by pleading guilty, including the right to have a trial.
Yes, sure.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or have it reversed, you would have to ask the next higher court, the Court of Appeals, to hear your case. If they said no, then that would be the end of any appeal of the plea. You understand that?
Yes, sure.
Has anyone threatened you with anything to get you to plead guilty?
No,
Has anyone promised you anything other than what we said here today in court?
no, Your Honor.
Is it your own free choice to enter this plea?
Yes, sure.
Are you pleading guilty because you are guilty? Mr. Thompson, I'm going to ask for you to inquire us the factual basis.
All right, thank you, Your Honor.
Thompson's going to ask you some questions about the circumstances. Okay.
Right.
So, Mr. Checks, you had a relationship with a individual, initials MA, is that correct?
Yes, Mr. Thompson.
All right, and that individual, did you have sexual contact with that person?
Yes, I did.
Did you have sexual contact with that person when she was only 15 years old?
Yes, sir.
All right, and you agree she was under 16 years old at that time?
Yes, sir.
All right, and you understand that's a violation of the laws of the state of Michigan?
Yes, sir.
All right, I don't have any further questions, Your Honor.
All right. With that individual MA, Mr. Checks, did you either have or attempt to have some type of penetration with your penis into her vagina?
Yes.
Ms. Koch, do you have any additional questions?
I do. Mr. Checks, was that here in Crawford County?
Yes.
No further questions.
Thank you. Ms. Koch, are the people aware of any threats, promises, or inducements other than what was placed on the record?
No, Your Honor.
No, Your Honor, thank you.
Ms. Koch, are the people satisfied that the court has complied with statute and court rule in taking up this plea?
I am, Your Honor.
Mr. Thompson?
I am.
Thank you. Mr. Checks, the court finds that your plea is knowing, voluntary, accurate. The court is satisfied there's a factual basis to support a finding that you are guilty of this charge. The court will accept your plea today. We'll set this matter for a sentencing hearing. You'll be notified at the date and time of that hearing. You're going to meet with one of the probation officers right after this hearing today to set up a pre-sentence interview. And then between now and the date of the sentencing hearing, it's important that you stay in touch with Mr. Thompson so that you're ready to go forward.
Already, Your Honor.
Your Honor, I believe because this involves a minor child and it's a CSC, that his bond is required to be revoked after the entry of a guilty plea by statute.
I know that applies to a first degree. I'm not sure about a third. I can check on that.
I think we need to check on that, especially if there's the possibility of Titus on the same.
Third is a
I don't believe it applies to third. Not as an attempt at-
Yeah, I'm looking at the law. I believe I recall instances where it has not resulted in remand, so I don't believe it applies, but I'll try to get the site for the court.
Okay, so just looking at, this is MCL 770.9B. And defendant convicted of sexual assault of a minor and awaiting sentence shall be detained and shall not be admitted to bail. I mean, in my view, Mr. Jack's has been convicted of an attempted sexual assault, so I don't believe that that would qualify. So we should take a contrary legal position.
No, thank you.
All right, so Mr. Jack's, you're going to continue to be subject to the condition of your bond. This is you have to during the pendency of this case, okay?
Already, Your Honor.
Make sure you continue to comply with that.
Yes, sir.
Ms. Falk, anything further?
My Honor.
Nothing further, thank you, Your Honor.
Thank you, Mr. Jack. Just make sure you meet with the police.
All right, thank you.
Our next hearing set for 10:45. Or be in recess until that.
by Zoom, but I have nothing in the court file or anything from anybody telling me that. The same thing for
Yankee was approved because,
Mr. McOsker was done yesterday as well, but I have, like I said, nothing in the file to reference that. Yes.
All right, Mr. Worden, you can unmute, please. Thank you. We'll go on the record now in People versus David Yankee, case number 235276. The record should reflect Mr. Worden's present today by Zoom. We have Ms. Koch present here in the courtroom. Defendant's present by Zoom as well. This is set for a status conference today. Mr. Worden, can you tell me where things are at with this case from the defense side, please?
Your Honor, there is presently a no plea offer status of this case. However, I believe there's room to negotiate. I talked to Ms. Koch this morning and she indicated a willingness to at least explore what I was proposing. So I'd ask the court for at least a couple more weeks to see if we can't get this resolved.
Ms. Koch?
he did contact me today and asked me about a different plea offer. I told him I would speak to the officer that handled the case, but obviously that was just an hour ago, so I have not had a chance to do that. That officer works nights, so I would not object to the adjournment.
All right, so Mr. Worden, what I'll do is the court will set this for a status conference plea hearing in about 30 days. And so at that point, hopefully whatever inquiries need to be made will have been made. And I'll just ask that you discuss any additional offers or negotiations with your client and that Mr. Yankee be ready with a decision as to whether or not he wants to go forward with any plea or go to trial.
Understood, Your Honor.
All right, thank you. Mr. Worden, anything else that we need to address for the record today?
Not from defense, Your Honor. Thank you.
Ms. Koch?
No, thank you.
Okay, thank you. That's all for this hearing today. The court will send out notice of the date and time of that next hearing. And that will be set as an in-person hearing. All parties on this file are free to disconnect at this time.
Thank you.
All right, Mr. Davis, if you can unmute, please.
Yes, good morning.
Great, thank you. Good morning. We're on the record now in People versus Chad McOsker, case number 235275. The record should reflect that Mr. McOsker's present today by Zoom video. And if I could have counsel put your appearances on, please.
Sierra Coke on behalf of the people.
And good morning, Your Honor. Maurice Davis, P76203, appearing with Chad McOsker, who's present appearing via Zoom.
Thank you. This is set for a pretrial conference in this case today. This is Mr. McOsker's first appearance before the circuit court in this file. Mr. Davis, have there been any plea offers, or can you tell me where things are at from defense's standpoint?
Yes, there has been a plea offer. We've had a couple conversations with the prosecutor's office about trying to resolve this. I was trying to work out a misdemeanor plea offer, but they aren't interested in doing that. So does Your Honor entertain Cobb's agreements?
No, it's the court's practice not to get involved in cops agreements. If you can come to some type of agreement with the prosecutor under what I view as kind of a killabrew arrangement where the court isn't committing itself. However, if the court were to not go with the agreement of defense and prosecutor, then Mr. McCosker would have the ability to withdraw his plea.
Okay. All right. So it may be worth one more discussion if the court wanted to grant another brief adjournment, well, a brief adjournment, set another pretrial conference for us to appear via Zoom, and we'll potentially have this case worked out that time.
Ms. Hope, any objection to that?
No, Your Honor, this is a co-defendant to the last case. And I wouldn't want to give one a different plea offer than the other, so I would ask for the 30-day adjournment as well.
What happened with the other case?
Same thing that's happening in this case.
Okay. Okay.
I think everybody wants another bite at the apple here in terms of trying to reach a resolution. So,
Right. Okay.
so what I'll do is, Mr. Davis, and this is what I did in the prior case with Mr. Yankee, is that the court is going to set this for a status conference plea hearing in about 30 days. So at that point, between now and then, Mr. Davis, whatever negotiating is going to take place needs to happen. And then if you can make sure that you communicate with your client and make sure that he's ready to make a decision about entering into a plea or not on that next date. If he wants to accept the plea agreement, we'll go forward with it at that time. And if not, then we'll just get it set for trial, okay?
Okay, sounds good. And who in the prosecutor's office should I reach out to? Madam Prosecutor.
Yes, me.
To the elected prosecutor, Ms. Koch. All right, Mr. Davis, anything else I can address for your side today?
What day are we scheduling it?
I can't give you a date today, but the court will set out a notice of the date and time of that hearing. It'll be in the first week of February.
Okay, and we can appear via Zoom, Judge?
If you want to submit a request to do that, once you receive notice of the date and time of the hearing, then the court will grant that, yes.
Okay, thank you.
Okay, Ms. Koch, anything further from your side?
No, Your Honor.
Okay, thank you. That's all for this file. All parties on this case are free to disconnect.
Okay. Have a good day.
Thank you. All right, Mr. Knoll, are you able to hear me okay? Mr. Seeger, are you able to hear me?
I am, Your Honor.
All right, Mr. Ziegler?
Yes, Your Honor.
Okay. Mr. Knoll, are you able to hear me? Mr. Knoll, are you able to hear me now?
Your Honor, I'm not sure if that's Mr. Knoll because it's labeled Saginaw Jail. And when I spoke to him this morning, he was in the Kilkasket County Jail.
Oh, okay.
Your Honor, this is Jonathan Russell. I thought I was supposed to have sentencing today in Crawford, but I got notice in the mail that was rescheduled for February. I'm not sure that the jail was aware of it. That's why I'm sitting here.
Okay, all right, thank you. I appreciate that. We're gonna go ahead and disconnect at this time. Thanks for letting me know.
Thank you.
I don't see Kalkaska's jail connected, so, I don't know, Mr. Ziegler, can you, have your staff call over there and ask them to?
I'll do that, Your Honor.
Okay, thank you. Everybody can just, remain on hold in this case. Are you ready on your file, Mr. Burton? I'm gonna take a case here in Kalkaska while we're waiting. So we'll go on the record, in versus David Burr. This is case number 235-200. The record should reflect Mr. Burr's present here in the courtroom today.
Sierra Coke on behalf of the people.
Adam Byrne on behalf of Mr. Burke, who is present standing to my right. Your Honor, last time we were before the court, there was a question as to whether the plea agreement that we had entered was accurate as to the amount of time my client would spend on the registry. We confirmed with probation and some other research that the 25-year registration period is the appropriate registration period consistent with the charges. The court had allowed my client to withdraw his plea in an effort to try and address that issue with the prosecutor. We were unable to address or make any changes. At this point, the prosecutor's position essentially is plead as charged or go to trial. My client has decided to accept has agreed to plead guilty to the charge of sexual conduct, 4th degree. It identifies as person 13 to 15. The language in the charging document identifies using force or coercion. I spoke to Ms. Koch about that this morning. I believe it was her intention to amend that to a person under the age of, or between the ages of 13 and 16.
That is correct.
Okay, so I just want to make sure that I make.
This is the language for that.
Sure that I make a clear record here this morning. So the court previously had taken testimony from Mr. Burr and found that there was an adequate factual basis to find him guilty of criminal sexual conduct under 750.520E1A. And then, as Mr. Vernon indicated at the last hearing in this case back in November, for the reasons stated, the court allowed Mr. Burr to withdraw that plea. So my question is,
It's still E1A, Your Honor.
okay, so my question is, can we simply just reinstate the plea that was previously entered in this case? Since we have Mr. Burr's testimony on the record, Mr. Vernon here.
So as long as we're clear that it's the E1A, the 13 to 15, and not the force or coercion under E1B, that is, again, that's the elements that were listed under that, then we're comfortable with the court accepting and reusing the testimony previously entered.
Okay, let's go.
I'm also in agreement with that.
All right. I think either way, the court would have an appropriate factual basis, but with that, but I do think that it's appropriate for the record to reflect the correct subsection. So that is 750.520E1A. All right, so the court will take judicial notice of Mr. Burr's prior testimony in this case. But I didn't want to go through Mr. Burr's rights again.
We re-signed the advice of rights.
Okay.
So.
All right, and so Mr. Burr, again, I want to make sure that you've had adequate opportunity to speak with Mr. Vernon about entering this plea today. Have you had that?
Yes. Yeah.
Okay, and do you understand everything that we said on the record here today?
Yes.
Do you have any questions about that, or do you want a chance to talk to Mr. Vernon before we go any further?
I'm okay, Your Honor.
Okay, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Burr, we've had this discussion previously, but I want to make sure that you understand the way things are going to go from today forward. So when you withdrew your plea back in November, essentially you regained all those rights that you had previously given up. You understand that?
Yes.
Okay. So by re-entering this plea today, you're going to be again giving up those rights. I want to make sure that you understand that. So as of right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent, until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you here at trial to question those witnesses. You have the right to have the court order any witnesses on your behalf here at trial. You have the right to remain silent during a trial, not have that silence used against you. You have the right to testify at a trial yourself if you want. You understand that you have all of those rights.
Yes.
You understand that you're going to be giving up and waiving all of those rights by entering this plea today.
Yes.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you'd have to ask the Court of Appeals, which is the next higher court up, to hear your case. If they said no, then you wouldn't be able to go any further with appealing the plea. You understand that?
Yes.
Has anyone threatened you with anything to get you to plead today?
No.
Has anyone promised you anything other than what we've said here in court?
No.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty because you are guilty?
Yes.
I didn't ask this at the beginning, but as to the charge of criminal sexual conduct 423 under 750.520E1A, what is your plea to that charge today?
Guilty.
Ms. Pope, any further inquiries that you need to make?
No.
Mr. Vernon?
Only as I said last time, that with regards to promises not made on the record, I did go over sentencing options with him, explain to him what we could do and what the court might or might not do. I did identify to him that the court's not obligated to do any things that he and I discussed, but again, as far as promises or inducements, I wanted to make sure that it was clear to the record that I did explain to him what the sentencing options for him were. We did go over his guidelines. I did score him and we discussed those things. Those may have resulted in some sort of an inducement to enter the plea. I want to make sure that the court understands and explains and the court is bound by those conversations and those scoring.
And I am aware of that.
All right. Ms. Pope, are the people aware of express promises or inducements other than what's been placed on record?
No.
Anything other than what you've indicated?
No, you're right.
Ms. Pope, are the people satisfied that the court has complied with statute and court will take it as a plea?
Yes, Your Honor.
We are.
The court finds that Mr. Burr's plea is knowing, voluntary, based on his prior testimony that is an accurate plea. The court is satisfied again based on the prior testimony that there is a factual basis to support a finding that he is guilty of this charge. The court will accept the guilty plea. Even maybe if you could just do a brief update. I'm sure there have been any changes there. Facts and update us. Anything else may have changed since October.
Your Honor, I do intend to speak with him, but would the court just want another full report since the last, with the plea withdrawn on the last one, would that just negate that PSI that was submitted? Just submit a new full PSI?
I think if you just want to resubmit the prior one with an attachment.
Correct with the, or just make the corrections that are needed.
Right, just like a supplement, but if you could have your office get a copy of the original PSI as well.
Okay.
Along with the supplement. All right, Ms. Polk, anything further on this file today?
No, Your Honor.
Mr. Burke?
I was just curious as to what the time frame for sentencing would be. I know that with the PSI already done, I want to make sure I had enough time to draft a sentencing memorandum.
It'll be set for 30 days.
Thank you.
I'm sorry, for the record, the court will adjourn the trial, which is currently set for February 12th.
Thank you. Thank you, Your Honor.
Thank you. Okay, if I could have the Kalkaska folks reconnect. To locate Mr. Knoll.
Your Honor, he is in the Kalkaska County Jail. The jail was not copied on the email from Jen this morning notifying us of the arraignment, so they didn't have him ready I was told they will get him available as soon as possible.
Okay, looks like they just popped in right now, so. Great, Mr. Nolan. All right, Mr. Knoll, are you able to hear me okay?
Yes.
Okay, we'll go on the record in People versus Jeremy Knoll. This is case number 234798, Kalkaska County case. Record should reflect Mr. Knoll's present today by video from Kalkaska County Jail. If I could have counsel put your appearances on.
Ryan Ziegler on behalf of the people, Your Honor.
Thomas Seeger appearing with and on behalf of Mr. Knoll for purposes of arraignment.
All right, and then we have Agent Barrett also from probation and parole present by Zoom as well. Mr. Knoll, you're before the court today for arraignment on a number of different probation violations. Have you been made aware of what the alleged violations are?
I have.
Okay. I need to go through a few things with you with regard to your rights. Number one, you do have the right to have a hearing as to whether or not you violated your probation in any of the ways alleged. You also have the right to have an attorney present at any subsequent proceedings. If you can't afford an attorney, one would be appointed for you. We have Mr. Seeger here for purposes of arraignment today. You understand those things I just stated?
Yes.
Also, if you are found guilty of any of the non-technical probation violations, we could subject you to the maximum possible penalty on your underlying charge, which is up to a maximum of 10 years for possession of methamphetamine. Do you understand that? Mr. Seeger, have you had any opportunity to speak with Mr. Knoll today?
I did, Your Honor. He would waive further reading. Additionally, Your Honor, I did review with him his request for assigned counsel. I would approve his application. I would ask that he turn that into the circuit court. And then I would assign Mr. Horowitz to his file.
Okay, and enter a plea of not guilty?
Yes, Your Honor. And Your Honor, I would note that the allegations, at least as I understand them, may stem from another county. And because they conceivably consist of a criminal component, I'm not sure how he'll wish to proceed going forward, but at this time, he would just ask that it be set in its ordinary course.
Okay, thank you. So the court will enter a not guilty plea on behalf of Mr. Knoll with regard to all of the alleged probation violations, and the court will set it for hearing. Agent Barrett or Mr. Ziegler, do either of you have any position with regard to what bond should be pending that hearing?
Your Honor, given the fact that he's been on bond for a drug offense while he was out, or excuse me, on probation, 7411 probation for that drug offense, and he committed allegedly an offense involving a delivery of controlled substances resulting in the death of an individual, I find that to be a quite serious violation, obviously, of his probation. I think he represents a danger to himself and to the community. For those reasons, Your Honor, I'd ask that he be held either on a high bond or with no bond pending that hearing.
Thank you. Agent Barrett, when was Mr. Knoll placed on probation?
Hold on, I'm looking for the date, Your Honor.
Okay, thank you.
I have it right here. Just give me 1 second. June 6th of 2023.
Okay, thank you. And how long was his term of probation?
18 months, I believe.
Okay, thank you. Mr. Seeger, anything on behalf of Mr. Knoll regarding bond?
Your Honor, on behalf of Mr. Knoll first denies the allegations is untrue. Second, Your Honor, he is entitled to a presumption of innocence. Then lastly, Your Honor, at least as I understand it, he's not had any prior bond or probation violations. And so he's asking the court for a bond that he would be able to post. He's not dismissing the seriousness of the offenses or the allegations, but he is denying them as untrue. He would just ask that it be set in its ordinary course. He does live locally. He does have work available to him. He is not a flight risk per se, Your Honor. At least as I understand it, he has been reporting to his probation officer, and it's not noted in the probation violations that he was failing to report. It's based on what's alleged to be new criminal conduct.
All right, thank you.
Your Honor, may I interject?
Yes, go ahead.
He does currently have a pending probation violation, which he's on bond for. That stemmed from new criminal charges in Grand Traverse County. He has since taken a plea in that case and is set for sentencing next month. So I was going to be getting him back on the docket to address the probation violation as well.
Okay. All right, thank you. Given the nature of the underlying allegation, which does involve delivery resulting in death, also involves allegations of possessions of ammunition and firearms. Given that Mr. Knoll has already violated probation once and by virtue of his guilty plea in Grand Traverse County, would be guilty of a previous probation violation in this case, the court has concerns for public safety, and those are the primary considerations that I find relevant in terms of the amount of bond in this case. The court finds that an appropriate bond would be $25,000 cash or surety given the circumstances. And Mr. Seeger, if Mr. Knoll is not going to waive the 14-day requirement, then the court would set this for the probation violation hearing within that 14 days if he's unable to post bond. Mr. Ziegler or Mr. Farah, anything else that we need to address for today's purposes?
No, Your Honor.
Your Honor, I would note that when I was speaking to Mr. Knoll, because he was unsure how he wished to proceed, that to the extent that he later determines that an adjournment may be appropriate, I told him that he could conceivably discuss that with his attorney.
Okay. All right. So unless the court hears from Mr. Horowitz, the court will set this for a hearing within 14 days. And that's all I have for today. All parties in this case are free to disconnect. Christy, if you're connected, I will get that on at some point today.
Thank you, Your Honor.
Thank you.
Okay, thank you, Your Honor.
Next hearing is, are you ready with Mr. Dreyer's case?
True. Yes, we are.
Okay. Take a brief recess to grab the report and that. Be right back. We're on the record in People versus Nicholas Dryer, case number 235261. The record should reflect Mr. Dryer's present here in the courtroom today. Expect to have counsel with your appearance.
Welcome back to the people.
D. Todd Williams on behalf of Nicholas Dreyer. Judge, I said Dryer for several months, but now I got it Dreyer.
Dreyer, okay.
Got it.
Thank you for that correction. All right, we're on the record today for purposes of a sentencing hearing. Mr. Dreyer, have you had a chance to review the pre-sentence report and go through that with Mr. Williams?
Yes, sir, I have.
Mr. Williams, are there any additions, deletions, or corrections?
There are none, Judge.
Any challenges to the scoring of the guidelines?
No, Your Honor.
Ms. Koch, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No.
Anything on behalf of the people for allocation?
The defendant is not being sentenced today on the RNO, but the drunk driving and then the follow-up to it was the RNO. It's probably one of the worst RNOs I've had, and I'm actually surprised I dismissed it. I looked at my plea agreement a couple times to confirm that. Now I'm going to say his last name wrong because we had this wrong, but Crawford, he actually finished sobriety court and was doing well in his life, and then just fell off the wagon. This was a bad situation. It could have actually ended up much worse for him. I think the recommendation for 12 months with 2 days served is appropriate. I'd ask the court to follow it. Thank you.
Thank you, Mr. Williams.
Judge, looking at this and reading the report and seeing the squad car video, the body cam or listening to what I could, there's no question that Mr. Dreyer exhibited some, it was reckless. And obviously the alcohol contributed to that fight or flight moment where he decided to, it was the futility of it. He was already pulled over and he ran, and the officer had to tackle him, and then this wrestling match ensued. I'm not saying that the deputy wasn't put in danger, but I don't think there was any intention of him to do any harm or anything to the police officer. I think maybe that's why the plea bargain was offered. Maybe not. Having said that, and as the prosecutor just mentioned, it's a shame. I've known Nicholas when he lived downstate. He finished one of the most difficult sobriety courts in southeastern Michigan in 2016. Had been sober for 6.5 years. He even got his driver's license back from the driver's license appeal division, which is a monumental task. Did you have an attorney for that?
Yes.
Okay, good. Well, because some people don't, some people do. Having said that, made his community up here, moved up here because the mother of his child that they had together moved up here, assimilated into the community, well-respected builder, and he's probably going to continue living in this community. And so Mr. Dreyer has to get back to the habits and the foundation that he was successful at. And I wish I could look you in the eye and say it's definitely going to happen. And I wish he could too, but he's just got to go back and do the hard work. As I looked at this and see the 12 months, I see that the guidelines are 0 to 17, so we're about in the middle. But the sentencing recommendation seems to be would have been a recommendation if he pled to both. I would be insulting the prosecutor, the people of this county, and your intelligence if I asked you to do the minimum 30 days, etc. But what I am asking, Judge, is for you to consider a 3 to 4 month sentence followed by an alcohol tether, not whether it be sober link or whether it would be a scram tether, whatever happens to be the case. He's certainly going to start going into whatever foundational requirements are in the jail, alcohol classes, things of that nature. But I would ask you to consider that, Judge. I know with good time and some other programs he'll be able to do, though, that might be something as well. Taking all those things into consideration and knowing what the county jail will do, I would leave that up to you. But I would ask you to consider a lower monthly sentence followed by scram tether, and obviously when he gets out, there's plenty of resources here. Certainly going to be some kind of outpatient program, things of that nature. And Judge, I failed to mention one other thing. The prosecutor graciously stepped to an adjournment. This was originally set for December 7th, and you allowed it. my client used the last 5 weeks wisely, getting a plan in place. He still owns a home here, has a mortgage, and with the help of the mother of his children, as well as a couple of friends, he's going to try to hold out as long as he can with regard to while he's in jail, maintaining his household. And as I said before, as long as his children are here, Mr. Dreer has to make his life here and in this community. So one way or another, he's got to get out, take advantage of the resources. I appreciate your time, Judge Among, and thank you.
All right, thank you. Mr. Dreer, anything that you wanted to say today?
Yes, as my attorney stated, I was sober for a lengthy amount of time. I fell off the wagon and I made a huge mistake, and I just have to start over. And I know I've had tools to be sober, and I know how to stay sober, and I intend on staying sober for the rest of my life. I had a really bad personal situation going on in my home, and I picked a very wrong way to deal with it. And I'd like to apologize to the court and to Crawford County Sheriff Department and my community.
All right, thank you. Excuse me, I did read through the report. I'm familiar with the circumstances of what happened here as is reflected in that report. There's also a lot of information in there about yourself, your background, past history, so forth. And so I take all of that into consideration along with what Ms. Cope and your lawyer had to say and what you had to say here too. I think given your past success in the sobriety court, this is surprising to me. Not necessarily that you had a relapse and even getting another alcohol-related driving charge, but your conduct in relation to the police officers here seems so extreme, given the tools that you've been given to deal with your issues as you successfully completed that program. Even though the R&O is part of the sentencing offense, it's not scored, it's not part of the guidelines. The court can take all kinds of information into account when fashioning an appropriate sentence. And I can't just pretend that that isn't part of this because it wasn't part of the plea agreement. Just like, what I consider to be mitigating factors are good things for you, which is things like successfully completing probation, having lengthy periods of sobriety. Those aren't part of this offense either, but I can take those into account too. I think you created a situation here by your actions, which I totally agree with Ms. Cope, could have resulted in deadly force against you. And could have resulted in serious injuries to yourself, to the officer involved, to the other individual who was involved in this. Just a situation that did not need to become what it became and was completely the result of your own actions. Also, in looking at the report, your statement indicates that you had 4 beers in a short time. Given your blood alcohol level of 0.18 on a blood test, I just don't know how you can get to 0.18 on 4 beers, no matter how quickly you drink. So I don't know. I'm not completely convinced that that's all he had to drink this night, or maybe there was some other substances involved. I don't know what's going on, but it doesn't make sense to me, knowing what I know about alcohol and its effects, that 4 beers can result in a 0.18 alcohol drop. So I say all of those things to say that I think those are all aggravating circumstances here. I think those are all things that call for a sentence. Number one, that provides a degree of punishment to you and consequence to your actions. Number two, that provides a deterrent effect so that people understand that if they're going to engage in this kind of actions directed at law enforcement, that there's a price to pay for that. I also think there's some mitigating factors here, and I mentioned those. The fact that you previously completed a sobriety program. I presided over one of those programs for 5 years. I know that they're not easy to complete. I know it takes a lot of dedication, a lot of work on the part of the people who successfully do that. So I think there is a potential for you to get back on the right track and move forward. And believe you when you say you're going to do that, because I think shown in the past, you can't do that. And I think that's probably part of the reason why the plea agreement is what it is. I think that convinces the court that a prison sentence isn't warranted, which I think you're right up against that. Even with the 0 to 17 range, the court can still impose. I think given your behavior here, in this case, it wouldn't be completely unwarranted. I think what moves you away from that is your past history and the successes that you've had and the likelihood that you're gonna be able to move forward. So I think jail time as recommended. I think probation is an appropriate sanction. I think it addresses both the punishment deterrence aspects, but also provides for probation and community sanction. So the court is going to follow the recommendation. I think it's fairly appropriate to place you on probation for a period of 24 months. The court is going to adopt the conditions of that probation, all the terms and conditions listed in this report. The court is going to order that you serve 12 months in the Crawford County Jail. You have credit for 2 days served. A crime victim's assessment of $130, supervision fee of $30 per month while you're on probation. Court cost of $325, the state cost of $68. You have the ability to seek an appeal of this sentence, and Mr. Williams on that table there should be a form of Mr. Troyer's appellate rights. Mr. Troyer, these papers are going to explain to you how to file an appeal if you wanted to do that, as well as how to request a court-appointed lawyer to help with that appeal. Mr. Williams, if you can now, Mr. Troyer, just now see those. You need to initial.
He needs to initial what, page 1?
Yep, date and time. Yep, he just needs to date and initial there.
Request, gotcha, and give you page 1. Date and sign. We acknowledge receipt. My clients. May I approach your clerk, Judge?
Yes.
Thank you.
That concludes the court's martial.